Okay, let's dive in. Imagine this. You've let someone stay in your place, maybe a friend, or perhaps you're the one moving into somewhere new. What's the deal? Is it just a casual nod, or is it something, legally solid, like a proper lease?
It seems simple, doesn't it? But that question really gets right to the core of some uh, quite complex property law concepts. It shows
Ah.
how everyday stuff can suddenly become quite legally intricate.
Exactly, and that's precisely what we're tackling today. We've got the scenario from a listener, Alex. He's allowed Bella to live in his flat under a specific agreement. Now, Bella reckons she's got a lease, with all the security that comes with it.
Hmm.
But Alex disagrees. He calls it a license, which is, well, much more like just permission to be there, less binding.
Yeah.
So our mission today is to unpack this whole situation and figure out what their arrangement really is in the eyes of the law.
And the absolute key here, the thing that unlocks this whole puzzle, is a term that sounds a bit technical: certainty of term.
Hmm.
But honestly, understanding this concept, certainty of term, is fundamental to knowing Bella's rights and Alex's obligations. We need to explore what it means.
And why it matters so much. Okay. So to help us do that, we're digging into a question and answer document that covers this kind of scenario. And we'll be looking at some really crucial legal cases, too, the ones that have basically set the rules here.
That's right. We're talking landmark cases like Street v. Mountford,
Hmm.
very important. Also, Lace v. Chandler, Prudential Assurance v. London Residuary Body, maybe Marchant v. Charters.
And especially relevant for Alex and Bella, I think, is Mexfield Housing Cooperative v. Berrisford.
Absolutely. Mexield is key here. These cases give us the framework, the tools, to distinguish between a lease and a license. They really show why having a clear duration is so important.
Right. So by the end of this deep dive, you listening should have a really clear grasp of the difference between a lease and a license. And you'll understand why this certainty of term thing is such a big deal in property law and how these court decisions guide us.
You should definitely have some aha moments as we piece this legal puzzle together.
Okay, brilliant. Let's start then. Certainty of term. Where do we begin?
Well, the absolute foundation for understanding what makes a lease a lease,
Mm-hmm.
you have to start with Street v. Mountford. That's the 1985 case. Street v. Mountford basically laid out the essential ingredients, the hallmarks of a lease.
Okay, what are they?
According to Street v. Mountford, you typically need a few key things. First, exclusive possession.
Meaning the tenant controls the space, can keep others out.
Precisely. The right to exclude everyone, including the landlord usually. Second, a fixed or periodic term. So the duration is clear or runs month to month, week to week, something like that.
Yeah.
Third, there's usually rent or
Okay.
some kind of payment or consideration. And fourth, an intention by both sides to create legal relations. They meant it to be a binding agreement.
Okay, so exclusive possession, certain term, rent, intention. Got it. That's Street v.
Street
Mountford.
v. Mountford, yes.
Foundational.
But, as we said, the potential problem, the real sticking point in Alex and Bella's situation seems to be that term. Their agreement says, and I quote, "This arrangement shall continue until Alex decides to sell the property or Bella fails to pay rent for 2 consecutive months."
Exactly. And this is where certainty of term really bites. It's a core requirement. This rule was stressed way back in Lace v. Chandler. That was 1944, Lace v. Chandler.
During the war, wasn't it? For the duration of the
Yeah,
war.
it's the one. The term was for the duration of the war, which the court said was uncertain. You didn't know when the war would end. And this principle was really cemented later by Prudential Assurance v. London Residuary Body in 1992. Prudential Assurance.
The rule essentially says, for a lease to be valid, its maximum duration must be clear, or at least ascertainable, right from the very beginning.
So you need to know the latest possible date it could end, even if it might end earlier.
Exactly that. You need that maximum lifespan defined from the outset. An uncertain end date generally kills the idea of a fixed-term lease. It highlights the danger of vague agreements.
Right. So back to Alex and Bella. Their end date depends on Alex selling could be tomorrow, could be never.
Hmm.
Or Bella missing rent twice, also completely uncertain when or if that might happen.
Precisely. And that kind of uncertainty is exactly what Prudential Assurance was all about. The court in Prudential was very firm. A lease term must be certain, because Alex and Bella's endpoint hangs on these unpredictable future events. Well, applying Prudential Assurance, it seems pretty clear their agreement fails the certainty of term test.
For a fixed-term lease, anyway.
For a fixed-term lease, yes. The end date just isn't knowable from the start.
Okay. So if it's likely not a fixed-term lease because of Prudential and the certainty rule, what else could it be? Alex thinks it's a license. Could he be right?
That's the next logical question. What is a license in this context? Essentially, it's just personal permission. The owner lets someone use the property. Crucially, a license often lacks either exclusive possession or a certain term, or sometimes both.
Ah, so exclusive possession comes back into it.
Absolutely. Remember Street v. Mountford. Exclusive possession is a key sign of a lease. The case Marchant v. Charters, that was 1977, Marchant v. Charters also touched on this. It suggested that without exclusive possession, you're probably looking at a license, not a tenancy.
Okay, so let's think about Alex and Bella. If Alex, say, kept a key and could enter whenever he liked, or if he provided cleaning services requiring access.
Then Bella probably wouldn't have exclusive possession. She wouldn't have that ultimate control.
And in that scenario, it points towards
A contractual license. Just permission, maybe backed by a contract, but not a leasehold interest in the property itself.
right. That seems fairly straightforward if she doesn't have exclusive possession.
It does. But, and this is a really important but, what if she does have exclusive possession? Let's say Alex gave her the keys, doesn't come in without notice. She has control.
Okay.
Even though the term is uncertain until Alex sells or Bella defaults. There's another key case we mentioned. Mexfield Housing Cooperative v. Berrisford, 2011.
Mexfield, yes. This is the one that offers an alternative.
It does. It's a really significant development. Mexfield dealt with a situation where an individual had an agreement with an uncertain term, but did have exclusive possession.
And what did the Supreme Court say?
They said, effectively, that the common law has this old rule. It was almost forgotten that an agreement for an uncertain term granted to an individual that's important could be treated as a lease for life.
A lease for life, really?
Well, yes, but then statute steps in. Section 149(6) of the Law of Property Act, 1925, converts leases for life into leases for a fixed term of 90 years.
Wow, 90 years.
Yes, a 90-year term. But, and this is crucial, determinable earlier, according to the agreement's original terms. So the uncertain events become break clauses.
Okay, hold on. That sounds complicated. Let's break that down for Alex and Bella. She's an individual. She might have exclusive possession. The term is uncertain.
Right. So following Mexfield, the starting point is that the law might interpret this uncertain arrangement as a 90-year lease.
Which sounds like a very long lease.
It does, but it's immediately qualified. That 90-year term can be ended or determined if the events mentioned in the original agreement happen.
So if Alex decides to sell, or if Bella misses 2 rent payments.
Exactly. Those uncertain clauses, which stopped it being a valid fixed-term lease under Prudential, now function as break clauses within this statutory 90-year lease framework established by Mexfield.
Or isn't there another interpretation of Mexfield or a related idea about periodic tenancies? That might be more common in practice.
Yes, you're absolutely right. While the 90-year lease is a technical legal mechanism Mexfield revived, in many practical situations involving regular rent payments like monthly rent, the courts might lean towards finding a periodic tenancy.
Like a month-to-month tenancy.
Exactly. If Bella pays rent monthly, the court could infer a monthly periodic tenancy. This is often seen as a more practical outcome reflecting the likely intentions. And crucially, this periodic tenancy would also be terminable on the occurrence of those specific events, Alex selling or Bella defaulting. They still act as conditions for ending the arrangement.
So under Mexfield, whether viewed as a determinable 90-year lease or perhaps more practically as a periodic tenancy, the outcome is similar in that the original uncertain conditions become the ways to end it.
Precisely. The key takeaway from Mexfield in this context is that even with an uncertain term, if an individual has exclusive possession, the law finds a way to recognize some form of tenancy, rather than just saying it's void or only a license. And those original conditions become the triggers to end that tenancy.
So again, it all comes back to that pivotal question. Does Bella actually have exclusive possession?
It really is the linchpin here. Does she control who comes in and out? Can she lock the door and keep Alex out, subject to perhaps reasonable access for repairs with notice? That points towards exclusive possession.
And why is nailing this down so vital? What's the practical difference?
Well, if Alex can wander in freely, provides extensive services needing access, it leans heavily towards a license. As a licensee, Bella generally has fewer rights, less protection against eviction, less security.
Okay.
But if she has exclusive possession, it supports the argument for tenancy, whether it's the 90-year Mexfield type or, more likely, an implied periodic tenancy. And tenants generally have significantly more statutory protection and rights regarding things like notice periods, repairs, and eviction processes compared to licensees.
Right. Much more security. Okay. We've covered a lot of ground, looked at Street v. Mountford, Lace v. Chandler, Prudential, Marchant, and especially Mexfield. Let's try and summarize the likely conclusions for Alex and Bella.
Okay, so based on the case law, outcome one. If Bella does not have exclusive possession, the agreement is almost certainly just a contractual license. Alex is likely correct in that scenario.
Simple enough. And outcome two.
Outcome two. If Bella does have exclusive possession, then despite the uncertain term, following Mexfield, the agreement is likely to be seen as a tenancy. This could technically be the 90-year lease determinable earlier, but is often interpreted more practically as a periodic tenancy, probably monthly, if she pays rent monthly.
And this periodic tenancy can be ended?
It can be ended if Alex decides to sell or if Bella defaults on rent for 2 months. Those clauses act as the termination conditions.
So prudential means it's not a standard fixed-term lease because of the uncertainty.
Correct.
But Mexfield provides a path, if there's exclusive possession, for it to be recognized as some form of tenancy, probably periodic, incorporating those termination clauses.
That's an excellent summary. Yes.
Woo-hoo.
Mexfield provides that alternative route where Prudential would otherwise just strike down the lease aspect due to uncertainty.
So what about Bella saying she has a lease?
Well, if she has exclusive possession, she might be right in the sense that she has a tenancy, which is a type of leasehold interest, thanks to Mexfield. But it's unlikely to be the fixed-term lease she might imagine. It's more likely that periodic tenancy.
And Alex saying it's a license?
His argument holds water if Bella lacks exclusive possession. If she has exclusive possession, his argument that it's only a license is much weaker because of Mexfield. He might still argue it's not a fixed-term lease, which would be correct due to Prudential, but Mexfield points towards it being some form of tenancy.
And which way would a court likely lean, assuming exclusive possession is present?
Given the precedent in Mexfield and the general tendency of courts to try and find a tenancy where exclusive possession exists to give occupiers security, they would likely follow Mexfield. They'd probably lean towards finding a periodic tenancy determinable on those specific events happening. It avoids the harshness of the agreement being potentially void for uncertainty.
Okay, fantastic. That really clarifies the different paths the interpretation could take. Let's just quickly recap the absolute key points for everyone listening.
Sure. We've seen Alex and Bella's situation hinges on whether their agreement has certainty of term. We saw that Lace v. Chandler and especially Prudential Assurance established that uncertain terms generally prevent a fixed-term lease.
All right.
But then we brought in the crucial Mexfield case, which shows that if an individual has exclusive possession, an uncertain term might not just make the agreement void or a license. Instead, Mexfield allows it to be interpreted as a form of tenancy, technically a 90-year lease, but often practically a periodic tenancy, which can be ended when those originally uncertain events occur.
So the big takeaways for you, our listener, are understanding that difference between lease and license, the critical importance of certainty of term, but also knowing about the Mexfield interpretation for uncertain terms when exclusive possession is in play.
Exactly. And you can see how these landmark cases aren't just abstract legal ideas. They provide the actual rules for figuring out these very real-life situations.
It really shows how a few words in an agreement or the understanding about who controls the space can have massive legal implications.
Absolutely. And it makes you think, doesn't it?
Yeah.
About all the agreements we enter into renting, subscriptions, even just informal arrangements. How many have these kinds of hidden legal dimensions?
Understanding concepts like certainty of term or exclusive possession, even basically, just empowers you to know where you stand.
Definitely food for thought. What other everyday agreements might be more complex than they seem on the surface? Something to ponder.
Indeed. Well, that's all we have time for on this deep dive. Until next time.